More than 300, sir.
Oh, more than 300. That's it.
309, sir, to be precise.
Oh, great. Very nice. Very nice.
YouTube.
Registered and joined in the meeting program also. Most of them are
347.
not joined in the meeting program.
Registered 347, sir, but joined in the meeting 309. But most of the people, 285 members are till last.
Oh, that's great. Fantastic.
Shireen ma'am, get ready and please start. Resolve 6 o'clock.
Respected Chairman of Vijayawada Branch, C.A. Godavarthi Srinivasarao, our resource person, Sri L. Jayaraman sir, managing committee members and fellow members, good evening to one and all. I welcome you all for the second day of 5 days virtual series of CPA programs on the subject Private Limited Companies under the Companies Act 2013. Hope yesterday you have already clearly updated on the basic concept like classes of companies and different classes of memorandum of association with the spectacular presentation by our Sir Jayaraman sir. Today sir is going to deal with the concept of articles of association and its related topic. Before moving to technical session, I request our chairman to speak few words.
Good evening, ladies and gentlemen. Respected Jayaraman sir, friends, I request only one thing. Please put your question and answers in the chat bar, in the Q&A, this thing. But please see that the question should be general one, not a specific or a personal professional query or something like that. If it is a personal professional query, sir is available in the WhatsApp, so you can put him directly to him. And if it is a general question which is useful to each and every person, kindly put it in the WhatsApp groups or even in the Q&A session. Without wasting much of your time, I hand over the proceedings to Jayaraman sir. Please, sir.
Thanks. So, good evening, my dear participants, members of the profession. Thank you very much, Chairman sir, for your kind words. The kind of response which I had yesterday, the tremendous response, gives me a great source of motivation to me. I was very happy to see that most of the members were till the end of the session, that the kind of zeal and enthusiasm with which they were participating gives me a lot of strength to proceed further. So we discussed up to Memorandum of Association yesterday. Now, continuing the discussion, we'll go into Articles of Association. Now, all of you know, articles also are not been specifically defined in the Companies Act, not possible to define also. Simply said, articles means articles as framed under Companies Act and altered as per the provisions of the Act. So in a general sense of the term, we can say articles contains bylaws, rules and regulations of the internal management of the company. Now, in fact, they tell the rights of the members inter se and the rights of the members vis-a-vis the company. In other words, articles, when the memorandum tells what are the main objects of the company, then the articles tell you how to achieve the objects. They mention the rules and regulations. But one very important point to be understood is the articles are subordinate to the Companies Act as well as the Memorandum of Association. Right. Now, continuing the discussion, now come to the main issue. Now, there are model articles given in the Companies Act. Table F is the model articles for companies limited by shares. 99% of the companies, they go for Table F of Schedule 1, the model articles. Right. Now, you have an option. Either you have your own articles of association or adopt Table F, the model articles. Or another option you got is you adopt your own articles then for those areas where there is no clear answer in your articles, then the table F will be applicable. Another issue now. In the SPICE form plus, they have already included the model articles. I checked up that model articles. This model articles which they have included in the SPICE form is nothing but the table F. They have just repeated the whole thing. Right. So now the issue is the articles also, when you adopt, you should also be divided into paragraph, consecutively numbered, stamped, signed by each subscriber, and should also be filed along with the memorandum. In the SPICE form plus itself, the articles, the model articles have been given. Now, I have found out some issues. The model articles, F, the table F model articles is common for both the public and private companies. The only one small difference is the 3 restrictive clause will be there in case of private company. But I find when I went through the whole thing, I find, as I already told you, they are common for both public and private companies. As a result, now many of the practicing company secretaries, chartered accountants, what they are doing, they are simply putting the 3 restrictive clauses and putting the first directors in that model articles, which is as per table F, and we are adopting that. I'm sorry for the language. If we do that, I think it is criminal. There are a lot of exemptions and privileges given to a private company under the Companies Act itself. If you have specific provisions of such adoptions of exemptions in your articles, in other words, blindly adopting table F for a private company is most undesirable. Now, every chartered accountant, company secretary must note this. Therefore, I would suggest that there are some minimum 25 to 30 areas where you should have your own articles and change that model pattern and insert your own clauses. This is the subject of discussion we'll have for some time now. So in the table F model articles, which is given the SPICE plus form, please look into these aspects and make the changes which you are permitted. The first and foremost point I want you to write is the regulations contained in table F in schedule 1 shall apply to the company subject to the additions, alteration, exclusion, substitution, variations set out below. In the event of any inconsistency between the provisions of table F and these provisions will remain. This is most important. What I'm saying is, first, as between our own articles as well as table F, our own articles only will prevail. Point 1. In case of conflict, second, if there are no answer in our articles, then table F will be applicable. Third issue, in case of conflict between our articles and table F, then our articles will prevail over. So this is the first point. I request all the consultants who incorporate a company to insert in your own articles in that SPICE form there. There are other areas which I will now discuss. Now, of course, the program itself, the software itself is designed that once you say it is company is a private company, obviously the 3 restricted clause will come in the articles. Because you know what is a private company? Private company does not become a private company just by its name. The 3 restrictive clauses appearing in the articles only make the company a private company. Fine, this is no big issue because the SPICE form plus itself, automatically the 3 clauses come. Now I want to discuss some issues. Now they have given the model articles. You can issue duplicate share certificate and you can charge 20 rupees. Now I would suggest, see, today the cost has gone up tremendously. 20 rupees is a very small figure. And after all, the members, when they are careless and they lost the share certificate for various reasons, you can put a higher figure. After all, today the administrative cost and all the board resolution passing, many procedures you have to follow. So better, in my opinion, you better charge minimum 100 rupees for each duplicate share certificate. I'm looking at certain practical aspects. Next, it is an atrocity that in table F, the model articles, there is no provision but for the general provision regarding transfer of shares. The share certificate, all has to be enclosed, the instrument of transfer stamped, all that it should be approved by the board. That is all fantastic. But we have forgotten the basic point in a private company. The basic point is the restrictive clause regarding transfer of shares restricts the right to transfer the shares. So in a private company, the articles must contain detailed procedure how to transfer the shares and how to register the transfer. In other words, all of us have read this point. A member of a private company, if he wants to sell the shares, he cannot give it to general public. He must first give a notice to the board of directors that I want to sell so-and-so shares. Then the price has to be determined by the board through a valuation method given the articles. Once the value and the price is ready, the board has to send a notice to all the existing members that Mr. So-and-so wants to sell the shares. If any of the if more than one of the existing members is interested, then probably some method can be adopted by the board to give it to one person. If there is only one person who is interested, obviously the board must give it to him only. If none of the existing members are interested, then only they have to sell the shares to the public. This is the restrictive clause. This is missing in table F. So if you blindly adopt table F, this is the biggest disaster. So all private companies, the very purpose of private company is to restrict the transfer of shares. After all, it is only a family concern, most of the private companies. So when a member wants to sell the shares and go out, let him go, no big deal. But you please sell the shares to us and then only go. So we as consultant will not be doing justice to the client if we blindly copy table F. So I request all the members on the consultants to understand this point and bring the real restrictive clause procedure for transfer of shares in case of private company. Then another point I observed was in a public company, for AGM, how many days notice you have to give? 21 clear days notice you have to give for AGM or even EGM in a public company. Then add 48 hours for sending by post. So it is 21 days, clear days plus 48 hours. What about what is the length of notice in case of a private company? Beautifully, the section says they can reduce the number of days, not increase it. They can reduce the number of days by special provisions in their articles. So, and I did not find any special provision in table F. In other words, in a private company, when you have got 20 members, 30 members, or whatever it is below 200, why 21 days? It becomes so difficult, particularly before AGM, when after the board approval, after the annual accounts is approved, giving 21 days notice is difficult. So I request all the consultants, all the members, that please make your own provisions in the articles. 14 days notice is enough. 7 days notice is enough. That should be fantastic for the AGM as well as EGM. These are all the freedom which is given to you. Utilize that freedom. Next, service of notice. The Act says it is applicable for all public as well as private company. Generally, notice must be given in writing, and the methods of notice, now electronic notice also can be given. It should be sent by ordinary post or register post, fax, all these methods. But in a private company, you can have your own methodology, which is quite different from what is prescribed. These are all the areas where you sit with the client for some time and then try to find out. These are all the areas where Act gives freedom for the clients, for people who start a private company. Next, entitlement of notice. The Act says notice must be given to every member, every director, auditor of the company, then debenture trustee, the list goes on. Now, in private company, you decide Anyhow, you have to give to the members. You decide to whom should be given, whom should not be given. If you want to give to some additional people, give it. What is wrong in that? It is left to you. So therefore, make appropriate provisions. Then similarly, appointment of chairman. The general clause says that the chairman of the board will be the chairman of general meeting. If no chairman is present within 15 minutes, then one of the directors will be the chairman. If there is no director present, one of the member will be the chairman. Proxies cannot be. These are general provisions. You give a thought to your type of company. You have any other ideas? Yes, you can insert in your articles regarding the chairman. At least you may not change it. You may not modify too much, but at least give a thought to this, all these areas. Then non-applicability of explanatory statement. You are aware that in case of any company, when special business, other than the 4 ordinary business, special business is transacted. I'm not talking special notice or special resolution. When special business is transacted, explanatory statement must be given. Explanatory statement should contain material facts, interest of the director and manager, then interest of the director manager, then if it refers to any contract, the time and place where the contract can be inspected, and also if the directors of the company have 2% or more of the shareholding in the other company, and the percentage, all those details are to be given in the explanatory statement together with the material facts. Now, if you read the section very carefully, explanatory statement gives the complete details, the background details to enable the shareholders to pass the resolution, whether ordinary or special resolution. My point is, in a private company, there's an element of secrecy. Therefore, if you want, you can write in clear terms, explanatory statement need not be given in the notice. So if they want, they can decide what should be the explanatory statement in the meeting. Let the director come and speak. So secrecy and privacy can be ensured. So these are the issues where you discuss. See, once you issue a notice, it becomes a kind of public document. Everyone will come to know. So explanatory statement, you can say in your articles that it will not apply, and the explanatory statement need not be given to the notice. Then notice of adjourned meeting. Usually, since no new business is discussed, no notice is given for adjourned meeting. But whereas in a private company, you can say, yes, notice of adjourned meeting also must be given. After all, the adjournment is done, and after all, you have 20 members, 30 members. Go for a better secretarial practice. Then quorum. See, we are blindly adopting that in a public company, in a private company, 2 members is the quorum in a general meeting. It becomes ridiculous, isn't it? When you have got 40 members, 50 members and all that, see, these 2 members become senseless, ridiculous. So you can go for a higher quorum. You can go for 5 members, 10 members, I mean, depending on the administrative and operational convenience. So also for board meetings. Board meeting, the law says 2 or 1/3, whichever is higher. Being a private company, we want larger participation of the directors. So if there are about, say, about 9 directors, what is wrong in saying majority will form the quorum? I mean, these are better administrative practices, better corporate governances, even in case of private company. The list goes on like this. Proxy provisions. You have standard proxy provisions in the Act. That is fine. In public company, it applies. In case of private company, you can have your own provisions. For example, you can say proxy can also participate in the meeting. Many issues. Then voting rights. We all know in show of hands method, I mean, irrespective of the number of votes, only 1 vote, most unscientific method. However, in show of hands method, proxies cannot vote, all that. You can have your own rules. Then casting vote, very important point. I have found out that we know what is a casting vote. In case of equality of the votes, the chairman will, apart from his vote, if any, he'll be given 1 extra vote to break the deadlock. Now, the right to casting vote is not an automatic right of the chairman. The right is derived from the articles. If the articles do not provide for casting vote, then equality of decision, there's a deadlock. So automatic right is not given. So you must provide in the articles regarding casting vote. I find in the table F, these things are missing. The story goes on like this. Then comes different rules for proxies, which I already told you. Then maximum number of directors, please see. The provision, I'm talking private companies. In the private companies, in a public company, there is a maximum limit of 15. After that, special resolution. But in private company, the whole section will not apply. But my point is, while you can have any number of directors, look at the cost of conducting a board meeting. So what is wrong in telling that maximum directors will be 10, 12, 8, something like that? When you're talking of ordinary finance company or ordinary trading company or some other company where you do not require too many directors and all, too many cooks spoil the food. I mean, I'm not saying that way. When it is not required, you always put a limit. You have to pay sitting fees and other expenditure is involved in today's world. So therefore, put the maximum limit as 8. So if they want, they can amend much later and increase the number of directors. Though up to 15 is permitted, why do you go up to 15? You ask the promoter, when they incorporate a company, put a 7, 8, 10, 12, 15, or whatever it is. So there should be clarity of rules and regulations. Then comes appointment and delegation of powers to the managing director. To my shock and surprise, I find nothing regarding MD in this model articles table F. Nothing is there. Now, for a private company, of course, the board will appoint, that is taken care by the section, board will appoint the MD. Then how the powers will be delegated? There are 5 methods by which you will delegate the powers. By writing the details in the memorandum or articles, or by contract method, offer acceptance method, or by board resolution or general meeting resolution. Then the catch point is, out of these 5 methods by which the managing director powers are delegated, which method you will follow? The answer depends on the articles. You write in the articles that the MD will be delegated powers through board resolution. See, please understand, practically, general meeting and board meeting does not happen on daily basis. It's only a statutory necessity. The real powers of management is in the hands of this one man called managing director, the man behind the show. So therefore, let it be very clear that you put an article that the powers will be delegated by the board. Let on day-to-day basis, the board, the MD report to the board. Then remuneration of MD. Though there is no restrictions, you put, let someone has to decide. Who will decide his remuneration? That makes all the difference. Then I found out, if you want to appoint additional director, the power is derived from the articles. Yes, in table F, there is a power, you can appoint additional director. Whereas in the same way, in alternate director, when a director goes abroad for 3 months or more, in his place, some other person is appointed, alternate director. The law says, the act says very clearly that an alternate director can be appointed if the articles so specify, or in their absence, the shareholders by ordinary resolution. My point is, in table F, this power is not there. Why again and again all this headache, asking the general meeting, ordinary resolution, all those things? Put the power in the articles itself to appoint the alternate director. Then operation of bank accounts. Many of the banks are nowadays insisting when you open a current account, though they insist on board resolutions and all, when they look at the articles, they find that there is no article regarding operation of bank accounts. So to how much freedom, who will operate the account, who will go for? So better you have a clear article. Then another interesting find I find is arbitration clause. Today, in case of any dispute among the members, dispute between the company and members, or something like that, dispute among the directors, better you insert, instead of going to court of law, better you settle the dispute through arbitration. These are some of the issues I just found out. If you go deep and compare the Companies Act and look into, better you have your own articles of association. When the law gives you freedom, why not you adopt this freedom? Certain statutory requirements Freedom are not there. Okay, that is given the Companies Act. That is fine. But where you can have freedom, apart from table F, please have your own articles and the client will be very happy. So you do one thing, you make your own model articles, which you can suggest to the clients to include all these points. Then only as a consultant, as a chartered accountant or company secretary, we are doing real justice instead of blindly copying the whole thing. This is what I thought I should bring to your knowledge. I'll spend some time on the enrichment clause, entrenchment clause, which is now included in the Companies Act 2013. Entrenchment clause in the Articles of Association. I will not be surprised if some of the older chartered accountants or someone, they do not know anything about entrenchment clause. This is a very interesting development in the 2013 Companies Act. I will start from the beginning. What is this entrenchment clause? This generally arises when you have groups of shareholders in family business concerns. And today we are talking of big investment. A single promoter does not have too much of money to invest his own money and start a company. So invariably, even in family business also, and in public and private companies, you've got groups of shareholders, mutual funds or even private equity funds also, they are prepared to invest and without being a promoter. Now, what is this entrenchment clause? The entrenchment clause says, I'll start from the beginning. Now, if you want to amend any provision in the Articles of Association, you have to pass special resolution. Every one of us know. But what you can do, you can put some entrenchment clauses and say, this particular article, if you are to amend, unanimous approval of all the members are required. You can put it. You cannot say that you cannot amend this particular article at all, because we cannot have a static memorandum or article. That is ultra vires the provisions of Companies Act. A particular clause. Now, for example, let us say you are going for buyback of shares. In buyback of shares, now special resolution is there. You can put an entrenchment clause that a buyback means usually special resolution around 75%. Number of votes in favor, 3 times number of votes against. Instead of 75%, you can say 80%, 90%, or 95%, or 100% of them must agree in terms of value. That is called making entrenchment clause, making it more stringent. More stringent. And not only that, see, so long as they are not violative of the memorandum, so long as they are not violative of the Companies Act, you can put certain entrenchment clauses to safeguard the management, the two groups of shareholders. That is called entrenchment. I'll come to that much later. First, how do you put that entrenchment clauses? At the time of formation of the company, this is permitted for both public and private companies. But for listed companies, stock exchange are going to regulate tremendously. So unlisted public companies and private companies, how do you put the entrenchment clause? Which means to amend that will be more stringent. How do you do? Either at the time of formation of the company itself or after the formation, by special resolution in case of public company and by unanimous approval of all the members in case of private company. You can put some entrenchment clauses. I repeat again, in a private company, at the time of incorporation itself, you put the entrenchment clauses, which means these clauses cannot be amended even by special resolution, something more than special resolution or unanimous approval of the members are required. Like that you can put. So you can put either at the time of incorporation itself or thereafter. If you want to amend the articles and put it, it should be done only through unanimous approval of all the members present at the meeting. Now, when you put those entrenchment clauses, as I already told you, it should not be contrary to memorandum and the Companies Act. This additional safeguard will raise the legal issues. Now, this is one area. to what extent it becomes contrary to the Companies Act and Memorandum. So there's a very thin line of difference. Certain validities will now be questioned in a court of law. I will now raise one example. See, suppose there are two groups of shareholders. Now they are putting an entrenchment clause like this. Say Mr. X group and Agarwal group. Say example. Unless the Agarwal family, which holds not less than 10% of paid-up capital of the list in favor of, he votes in favor of the amendment, there cannot be any amendment in the articles. This entrenchment clause, but this seems to be very unreasonable, isn't it? This seems to be very unreasonable. So I'm not going deep into this. To what extent you can put this depends on facts of the case. For example, another example, let us take, you have to give, let us say, in a public company, 21 days notice, or your articles provide that you should give 7 days notice for a general meeting. Now you are putting an entrenchment clause and saying, no, 25 days notice is required, 30 days notice is required. So that's a constraint that is permitted. But you cannot go contrary to the Companies Act and say, no, in a public company, 15 days notice is enough, 10 days notice is enough. So like that, particularly when there are a group of shareholders, each has got their own stakes in equity as well as the management. In order to have their own say, they can have entrenchment clauses. In other words, once you have entrenchment clause in the articles, then changing them will be more stringent. For example, where you will have this entrenchment clauses, usually closely held companies to restrict concern, maintain the status of closely held, family-owned companies with ensure control of management, and third, companies in which there are some private equity investor who intend to have more control over the management, and then some joint venture companies may put restrictive covers on the other joint venture party. Let's look at some more examples. To provide for affirmative vote to a joint venture partner or strategic investor. He says, so-and-so provision the articles are to be altered, means the other person also must agree. Subject to reasonableness, you can put it. Because I have joined this company as an equity partner based on this understanding. Then you can even say, wherever ordinary resolution is required to be passed, no, please pass a special resolution because of entrenchment clause. You may say how it is possible, because the members have agreed. The private company, this becomes the foundation for starting the company. They may say, alteration of share capital, I don't think it will be contrary to Companies Act. They want to put it more stringent, that's all. Wherever ordinary resolution, they may say special resolution. For example, they may say, if you want to issue bonus shares, let us pass special resolution. What is that? Though the Act says ordinary resolution is enough, you can go for entrenchment clauses. These are new areas where a lot of study, a lot of debate and discussion has to take place. Then resolution require unanimous consent for certain items. Wherever they said special resolution, these resolutions, no, we cannot want special resolution. We want unanimous approval of all the members. Put such entrenchment clauses. Then issue of shares. Certain shares cannot be issued. Certain shares can be issued with so-and-so approval. Restrictions on voting rights on resolution. These are all new areas which are opened up in the Companies Act. Higher notice period for the meetings. That's what I told you, not lower period. In a public company or in a private company, say your articles provide for, say, regular 21 days, even private company, you can say 25 days, you can say 30 days, if it is going to serve some purpose for you. Then requirement of additional information, explanatory statement. Apart from what the Act says, in a private company, you can say, the so-and-so information ought to be given. And you cannot amend that. Once you make an entrenchment clause, then if you want to amend it, then very stringent. Something more than special resolution will be required. Higher quorum, election of chairman, right of proxies to speak. Many issues, many issues. This will open the Pandora's box now. See, these are all the areas. Give freedom to a private company and public company also. Because now The idea is there are 2-3 groups of shareholders, private equity, joint ventures. One group is taking control of the management. Other group also would like to have some say. This is how it is. This is how it is. Then similarly, let's continue to provide for a poll facility for voting. There are 2 methods of voting, show of hands method and poll method. When I come there, we'll see. So now you can say, if you put an entrenchment clause, no, every matter directly let it go for poll method because it is scientific method. Though it is expensive, doesn't matter. Then providing the business in addition to act, which requires special notice. For example, removal of CFO, chairman, all these people, special notice must be given. It has to go through members. You can put that. Provided they are reasonable, not conflictory to the Companies Act. Then power to refuse transfer of shares. Then additional disqualification to directors. We'll discuss that later. In a private company, they can provide for additional disqualification for directors, that you must deposit so much money in the company, you must have so much qualifications, you must have this experience. Those things you put it and make it an entrenchment clause. You cannot amend all this. I mean, you cannot amend it by just special resolution. These are the areas. So this entrenchment clause facility is now available. That is for both public and private companies. That is what you can do. Certain matters you can say it cannot be amended by just passing special resolution. It has to be amended more than special resolution, say 90%, 95% majority or unanimous approval of all the members present. These are called entrenchment to make it more restrictive. Again, I repeat, how do you bring that entrenchment clause? 2 methods. One is at the time of incorporation itself, you put some entrenchment clause. Second is thereafter in a private company, that entrenchment clauses has to be inserted only with the approval of all the members present at the meeting. This is one area which requires a lot of discussions and focus to be done. Now, I'll just quickly run through some of the issues because you already read this at your final level or inter level. I'm only trying to reinforce or re-emphasize the importance. Legal effects or binding effects of the memorandum and articles. Now, suppose A and B enters into contract, some contract. A is bound to B because of the contract, B is also bound to A because of the contract. That contractual relationship is created. But then the beauty of the Companies Act memorandum articles is the moment a person becomes the member of the company and the moment his name is entered in the register of members, an automatic contractual binding effect is created. Whether he likes or not, he is bound by the memorandum and articles. 3-4 binding effects let us examine. There need not be a specific contract. I repeat again, the legal effects of memorandum articles is the moment he fulfills the application in writing, allotment, name entered in the register of members, all that is over and he becomes the member, automatic binding effect is created. What are the 3 automatic binding effects created? First, member bound to company. In other words, whatever is stated in the articles, member has to follow. For example, it is written in the articles, when the member gives a notice to the company, you should send it only by hand delivery or register post. You cannot send by ordinary post. Say example. Now member cannot question, you will write whatever you know. Who will spend so much money for the registered post and all? No, you have no option. You have to send it by register post or ordinary post or hand delivery only. So therefore, if you want, you should read the memorandum articles before you become the member. It's a very interesting point. And there were 2-3 case laws also. In one case, it was written in the articles when a member becomes insolvent. We don't want the member to go through the insolvency proceedings. So it was written in the articles, the board will immediately sell the shares without telling him. And whatever money they get will be handed over to him. So this is what is written. But then one fellow became insolvent and said, you will write many things in the articles, who will follow? No, you have to follow. A binding effect is created between member and company. That is, members have to simply follow whether they like or not, because automatic binding effect is created between member to company. Second, similar binding effect is also created between company and members. Company also have to follow, when they deal with the member, all the procedures given in the articles for forfeiture of shares. Suppose they have given 2 notices, you have to give 2 notices. Declaration of dividend, some procedure is given, you have to transfer compulsorily something to general reserve. You have to follow that. So when the company deals with the member, this memorandum articles becomes the Bhagavad Gita document. You have to simply follow. If the company does not follow, any member can go to court and get an injunction order. So 2 binding effects is very clear. Memorandum articles becomes the base. When the member deals with the company, simply follow everything, whether contract is entered or not. Second, when the company deals with the member, they have to also simply follow. The third issue now arises is whether the memorandum articles create a binding effect between member and member. For example, let us say one member does not, a group of members or 10% does not pay the call money. You know, when they don't pay the call money, the project is delayed. When the project is delayed and the company is affected, majority members are also affected. So it has a cascading effect. So my point is, can the majority members write a letter directly to the minority members that please pay the call money, because of you we are affected? Does it create any contractual relationship between member and member? The law beautifully says, yes, it creates, but that cannot be enforced directly. It has to be enforced through the company because of legal entity. In other words, the majority member has to write to the company and company will take action against the minority member. So the point here is, yes, there is a binding effect between members and members inter se. Memorandum articles creates it. But the binding effect cannot be directly enforced. It has to be enforced through the company. Then what about the binding effect between company and outsider? All of you have read it. And just to bring a correlation, I am just quickly touching upon it. Now, very interesting point is, memorandum and articles cannot be used as a mechanism to create a contract between the company and outsider. For example, as a company secretary, I am an outsider. I am a practicing company secretary. Suppose the company, without telling me, has written in the articles. The company, without telling me, has written the articles. Mr. L. Jaraman, the practicing company secretary, will act as secretarial consultant to the company or an employee to the company, and he will work from morning to evening, Sundays, no holidays, on a salary of 1,000 rupees per month. And they registered it. And they did not tell me. Next day, they come and tell me, Jaraman sir, sorry, sir. We did not tell you, but we have included your name in the articles. Please stop all this practice and join my company tomorrow. What I will say, get lost. Memorandum articles cannot be used to create a contract between company and outsider. Just because you write something in the articles, it is not going to bind me. This was told very clear in the ALA case. In the ALA case, they made it, because if you want to enter memorandum, the contractual effect will come only through contract, through offer and acceptance method. So the first point is, outsider signifies a person. So the memorandum articles cannot be used to create a contract between outsider and company. Consequently, neither the company nor the outsider is bound by the articles. So for example, all of you read this ALA case. It was written in the articles that ALA cannot be removed from office except by misconduct. They did not. Then there was no contract between company and ALA, but ALA was acting as a solicitor. One day, the board of directors removed ALA on some other grounds other than misconduct. ALA went to the court. Yes, the court, the ALA went to the court on disciplinary grounds. The court said that, constitute a contract between the court held ALA has no cause of action since articles did not constitute any. Neither you are bound nor they are bound. Next. However, the ALA case was later modified in the Port Darwin gold mining case. In the Port Darwin gold mining case, what the court said, don't blindly, they accepted 50% of the case in the ALA and removed the 50%. What the court said, while memorandum articles cannot be used to create a contract between the company and outsider, the contract has to be entered, offers or acceptance method. The articles can specify some of the terms of the contract which are not contrary to the Companies Act. See, for example, a person was appointed as managing director, appointed, not just writing his name in the articles. Offer acceptance method, a person was appointed as a managing director. And in the appointment letter, some terms and conditions were agreed. Fine, salary, remuneration, all that. But in case he is terminated, what will be the compensation for loss of office? Nothing was agreed in the agreement, but in the article, somewhere in one clause, it was written that in case he is terminated from service, he will be entitled to so-and-so compensation. Now, this MD was terminated. Though the contract did not contain anything, the court said MD can get the compensation because in the Port Darwin case, the articles can tactically adopt some of the terms and conditions of the contract, provided they are not contrary to the contract itself. So this is the legal effect. You read all this at your interlevel. I just thought to bring to your notice. So first contractual effect, company is bound to member. Second is members are bound to company. Members and members are bound to inter se, not directly through the company because of legal entity. When it comes to outsiders, memorandum articles cannot be used to create a contract. Contract has to be entered. But once you have entered into contract, some of the terms and conditions can be tactically adopted in the articles. This is what he says. The next area of discussion, we will look into these two interesting doctrines, Doctrine of Constructive Notice, Doctrine of Indoor Management. See, what is happening is, once we read all this at the inter stage, by the time you read the inter, many of you, even if you are qualified recently, out of sight is out of mind. And this has tremendous implications. So I will take another just few minutes to finish these two and go again. Doctrine of Constructive Notice, Doctrine of Indoor Management. Doctrine means well-established case law. You all know what is this Doctrine of Constructive Notice. It says memorandum articles are public documents. So any outsider dealing with the company must read the memorandum articles, must understand the provisions, and deal with the company as per the memorandum articles. In other words, it is the outsider who deals with the company must know, must verify whether the internal procedures are followed or not. If the outsider make negligence in finding out, he will be affected in the contract. In other words, in a simple language, I'll tell you, it is very clearly written somewhere in the articles that the managing director can borrow money from a person only after board resolution, general meeting approval is taken. So now a person wants to give loan to the managing director. It is the duty of outsider to verify whether the managing director has got these powers, whether the board meeting has really taken place, whether general meeting has really taken place, and then only you should give the loan. Tomorrow it turns out that these things, internal procedures are not followed, it is the outsider who will suffer. This is the Doctrine of Constructive Notice. So they have two powers has been delegated. So here the doctrine prevents any person from alleging that he doesn't know the provisions. Every outsider dealing should ensure they follow the procedures. So for example, in one case, the articles required all the document must be signed by MD, secretary, and working director. A particular document was signed only by secretary and working director. They said the outsider has to suffer. You have to ensure, outsider has to ensure, you read the memorandum articles, you ensure that this is the signature of MD, this is the signature of the director, this is the signature of the secretary. If you make any negligence, as a result of which the contract, you will be affected. But this Doctrine of Constructive Notice became too difficult. In 1856, 100 years before the Companies Act 1956, this was replaced by the Doctrine of Indoor Management. Now, no longer you have constructive notice. Constructive notice is only available in government contracts, if you want to see. Suppose, let us say, the one IAS officer or one IPS officer, because of the position, he signs a contract to execute a government project. Now it is the outsider who's dealing with that government has to ensure that Palason's officer has the powers, all that you have to go through. If the officer does not have powers, you have to suffer on the contract. But then now the doctrine of indoor management has come. The doctrine of indoor management protects the outsider, unlike the constructive notice. The doctrine beautifully says, where the proposed contract is not inconsistent with the memorandum articles, it is not the duty of outsider to verify whether the internal procedures have been complied with. The outsider is bound to presume the internal procedures have been complied with. You know, this Royal British Bank Turkon case. Now in this given example, suppose it is here also you have to consult the memorandum articles. Suppose it is written the articles that MD can borrow money after taking board resolution approval and general meeting approval. You want to give some loan to the MD on behalf of the company. And the MD gives you, sir, this is the board resolution they have passed. Sir, this is the copy of general meeting resolution. Then, is it the duty of the outsider to verify really board meeting has taken place? Really general meeting has taken place? No. He is bound to presume. I'm using not negative language. You do whatever you want, I'm not bothered. No. The outsider is bound to presume that the board meeting has taken place, general meeting has taken place, even if they have not taken place, because I cannot verify all your internal procedures. So the outsider is protected. So today we are able to deal with all the companies because of indoor management. But you have to take the basic precautions. So this was given in the Royal British Bank and Turkon case. Now, this doctrine of indoor management, I repeat, any person dealing having satisfied the proposed contract is not inconsistent. He is not bound to inquire into the regularity of the internal proceedings. Right. Now, there are some exceptions to the doctrine of indoor management. Back to square one. Like outsider is not protected, company is only protected. What are the exceptions? First, when the outsider has not consulted the memorandum articles, very important. What the doctrine of indoor management says, you read the memorandum articles. If you have not read itself, you have to suffer. You read the memorandum articles, then you need not verify the internal procedures. That's all. You can presume that internal procedures have been complied with. That's what it says. For example, it's written very clearly in the memorandum, in the articles, the MD cannot exercise borrowing powers unless approved by the, cannot exercise the borrowing powers. And this fellow did not consult the articles. Then he gave some money. Now, no doctrine will protect him. Because had you consulted the memorandum articles, you would have known in very clear terms that this MD does not have power. So first exception is you have to read the memorandum articles. Second, the outsider fails to make reasonable proper inquiries. Beautiful point. See, every outsider, when he enters into contract with the company, always you should not do the japa of indoor management and all. You should also behave like a man of ordinary prudence. You should use your common sense. Common sense is a sense which is uncommon in man, we call it. You should behave like a man of ordinary prudence. For example, I'll take one simple example. One advertisement was given in a newspaper that the company wants to sell its old ambassador car and as is wear condition. So this fellow went to the registered office early in the morning at about 8 o'clock. Who will be there at 8 o'clock at the registered office? Only the chowkidar will be there. So he went to the chowkidar and asked the chowkidar, look at the intelligence of that fellow, asked the chowkidar of Reliance Industries Limited, hey, I read that one advertisement is given, they want to sell the car. So what is the price of the car? Dealing with whom? Chowkidar. And the chowkidar took advantage of it and said, okay, sir, tell me, come on, take the keys, go around and come. He went around and came. And what is the price? Chowkidar says, sir, 1.5 lakhs. No, 1.5 lakhs is too much. I'll pay only 1 lakh. Chowkidar said, okay, sir, please take. And on behalf of Reliance Industries, Chowkidar signed all the documents for Reliance Industries. And this fellow took the car. And by the time he went home, police was readily waiting for him. You should have common sense that Every time you cannot say on behalf of the company someone has signed it. Senseless. On behalf of the company, who will sign? It depends on the facts of the case. Yes, administrative officer or a managing director or some senior officer, manager must sign. So a chowkidar, a clerk, a driver will not have power to sell the fixed assets of the company. So always you cannot say this doctrine will protect me. You should make some reasonable, proper inquiries. Next, during suspicious circumstances, further reasonable inquiries. What is suspicious? Depends on facts of the case. This officer says, I've got powers. Then another officer says, no, he doesn't have powers. Then you take more precautions. Who has got powers on behalf of the company? Then the fourth exception says, when the outsider has actual knowledge of want of authority. These are all the practical things you should tell the client. For example, it is written in the tender documents very clearly by the company that when we give the final contract, the final contract, the contract will be signed by the managing director. Clearly, it is given in the tender documents. Who will sign on behalf of the company? Managing director. The MD went on leave. The tender was finalized. This outsider, he knows pretty well that the final contract has to be signed by MD. And since MD has gone on leave and no delegation was done, he forced the purchase manager to sign the contract and give it to him. I'm knowing pretty well purchase manager does not have the power to sign. No, this doctrine will not protect you. It's not that anyone will sign on behalf of the company. Company will not take responsibility. When the outsider is cheated on a forged document, this you must know clearly. Forgery will not have any legal effect, however genuine it might be. The great Fingal case everyone knows. I'll just quickly tell and finish it off. In the great Fingal consolidated case, one shareholder, he applied for the shares. Somehow the shares were not allotted, not the refund order was given to him. After waiting for 6 months, he went to the company and shouted at the company secretary. The company secretary, stupid fellow, instead of verifying all the details, he took a blank share certificate and he put his name and he put all the details and put some distinctive number, this, that, and he affixed the common seal without authority of the board, and he forged the signature of 2 directors, and without writing the details in the share transfer register or the shares, he just handed over to him. That outsider was very happy. Then after some time, when dividends were declared, it was not paid to him. Obviously, he is not a member. When he came, this time there was a new company secretary. When he gave the share certificate, the company secretary was shocked. But the outsider, now the shareholder says, I don't know all that. Your people have given the share certificate. So the doctrine of indoor management will protect me. No. When there is a forgery involved, he did the signatures of forgery of the 2 directors. So the doctrine will not protect. If this point is not there, what will happen? MD signature, everyone will forge and give it to outsider, the contracts, and then the company made responsible. Stupidity to the core. So forgery is involved. In the same example, if the company secretary has confused or convinced the 2 directors and made them sign, then probably this share certificate will be binding on the company. So this is the exception. The last one, the rule will not apply to illegal and void transactions. Suppose, say, for the fun of it, Reliance Industries marketing manager gave a contract to some Supari contract to kill 6 competitors. Now that fellow, instead of killing 6 competitors, he killed 10 people, 4 bonus. And now when he comes for payment, the marketing manager says, "Arey yaar, I don't have these powers here. Only MD has these powers." Now outsider says, "I don't know how that doctrine will protect me." What protect? Nothing. Basically, the contract should be legal. Then only the question of doctrine arises. So please keep in mind that this doctrine of indoor management and the exceptions, the outsider who enters into contract with the company has to read the memorandum articles and ensure his contract is not against the memorandum articles. That's all. He need not verify the internal management, internal rules and regulations pertaining to the contract. I'm not using negative language. I'm only saying that the outsider is bound to presume that the internal proceedings have been complied with. All that you should have read at your study level. Anyway, it's very important. So I brought it to your knowledge. And there are a lot of exceptions. You can these exceptions play a very important role. You must make some reasonable efforts. You should genuinely believe that the contract is correct. Then you are protected, not otherwise. Now, quickly running through, we'll now run through articles, alteration of articles of memorandum of association. How do you alter the memorandum? I told you cannot have a static memorandum. Static memorandum means that it cannot be altered. It is ultra vires the provisions of the Companies Act. Any provision, the memorandum articles can be altered subject to the procedures and restrictions given the Companies Act. So any memorandum can be altered. Now you all know name clause can be altered by special resolution with central government approval. Whenever I say central government, it means Department of Corporate Affairs, New Delhi. Now, of course, though they have said the central government, in the delegation of powers, the powers have now been delegated to ROC itself. You know, there are 3 separate offices. They are not interchangeable office. The documents which you are to file in one office cannot be filed in another office. First one is central government, Department of Corporate Affairs, New Delhi. That is different, headed by the secretary, New Delhi. Second, regional director's office, RD office, Delhi, Madras, Bombay, Calcutta, Hyderabad, Bangalore, Ahmedabad, like that, RD officers are there. Below them, you have ROC officers. Fine. So how do you change the name of the company? Special resolution. See, again, what is special resolution? Don't say 75% majority and all. Number of votes in favor of the resolution should be 3 times number of votes against the resolution. For example, if there are 100 votes, 66 in favor, 22 against, passed. 88. What about the 12 votes? Rejected, not voted, voted wrongly. So number of votes in favor should be 3 times number of votes against. And you have to obtain the central government approval. Now, before that, why will you actually change the name of the company? What are the probable causes and reasons? 1, merger, amalgamation, takeovers. So they want to remove the group identities of the old group and now bring new identity. Fair enough. Second, they change the objects of the company. To reflect the new objects and all, you try to change the name. Third, for sentimental purpose. This is very peculiar in our country. He does all nonsense in the business and puts the blame on Vastu, numerology, astrology, astronomy, whatnot. You be ethical, things will become all right. Anyway, so they will say, add this word, remove this word, add this letter. All that happens in our country. So for sentimental reasons also, you try to change. Another trend I find today, the change of names is abbreviations. Now, people have no interest, no patience to remember big names. ICICI Limited, that's all. Industrial Credit Investment Corporation of India Limited. We don't want IFCI Limited, IDBI Limited, ITC Limited, VST Limited, like that. Abbreviations also like that. So these are the, please ensure that you don't change the name on frequently. Frequently changing the name is not really helpful because a lot of goodwill is spent on the company. So there should be some valid reason. That's why government will look into that. What is your objective in changing the name? Are you trying to mislead the general investors? And overwhelming majority special resolution has to be passed. Then all of you know, addition in conversion of a company from private to public or public to private, addition of the word private or deletion of the word is not alteration of name. So this procedure need not be followed. There's a separate procedure. We'll come into that later. Sorry. Next. And one more rider now. If you want to change the name, you have to ensure 2 things. The annual returns and financial statements have been filed with ROC. No pending filings. Second, then to protect the creditors, mature deposit, debentures, interest has to be paid. In other words, I'm going to give this facility only to law-abiding companies, the change of name. Then, after the change of name, all this procedure is effected, you have to apply to the Registrar of Companies, and Registrar of Companies will issue a fresh certificate of incorporation consequent to change of name. So the change of name will be effective only from the date in which the fresh certificate is given by ROC. Though I am using the word fresh certificate of incorporation, it doesn't mean that old company is killed and new company comes into existence. Whatever acts you have done in the old name will continue. So the old litigations, share certificates, everything will be valid. Old contracts, litigation, everything will be valid. Maybe from today onwards, you use the new letterheads, bill heads, new share certificates with the new name. That's all. So some housekeeping work you have to do that make necessary changes in the memorandum articles, name boards, letterheads, and all that. Then if you want, you can even give an advertisement, all that housekeeping work. Apart from alteration of name, there is one more section called a rectification of name. Alteration of name has a different meaning in terms of procedure. Rectification of name also has a different meaning in terms of procedure. Rectification of name arises only when the name was given to you. Yesterday I told you that ROC will make only preliminary inquiries. ROC giving you the name is not conclusive evidence. So ROC has given the name to you. Some company already existing in the market now makes a complaint to ROC. We'll call this the second company. That existing company is the first company. So first company will give a complaint to ROC. Sir, this name, whatever you allotted and with which the company is incorporated, is similar or identical with my company, and he is trying to misuse my goodwill. He's trying to misuse my goodwill as such. Then probably, if the central government is convinced, they will give a direction to rectify the name. That's called rectification. This rectification also has to be done by passing ordinary resolution. Alteration of name voluntarily, special resolution. Rectification by ordinary resolution and central government approval. This has to be carried out within 3 months. Now, if it is regarding the resembling with the registered trademark, this is another issue. Now, yesterday also one participant raised the issue. Let us say originally about 10 years back when ROC approved the name, there was no registered trademark. Best example will be Reliance Cellulose Limited, one company in Hyderabad, private limited or limited. That came much before Reliance company was started, before trademark was registered. So the Reliance Cellulose was there and is nothing to do with the Reliance group. Thereafter, when Reliance came, his trademark was registered and all that. So if Reliance wants, he can now ask that the registrar that, see, this first company must change the name because he's using my trademark or something like that. So if the dispute regarding trademark is involved, then instead of 3 months, 6 months time is given to you. But then this also has to be done within 3 years. The dispute after incorporation of the company, second company, within 3 years, the first company has to object. So after 3 years, it could be anyone's game. Who is violating whose trademark? It could be anyone's game as such. So when they changes the name, then you have to give the notice to ROC within 15 days and all. Then come to change of registered office. Quickly, I'll run through because back to basics. Many of them we are forgetting. Change of registered office of the companies are 4 categories. We are mixing up the procedures. Change of registered office of the company from one place to another within the same town, village or city, separate procedure. Hyderabad to Secunderabad, from this address to that address. The Hyderabad, Secunderabad are twin cities. Within that, how do you do? Just ordinary resolution. That's all. And you inform the ROC with the prescribed form. Very simple. Board resolution. Board resolution. Board themselves can take a decision and you inform the ROC. Where are you changing the registered office? From one place to another within the same town, village or city. Second, change of registered office from one town, village or city to another within the same state. Of course, now Telangana state is different, Andhra is different. So now I want to change the registered office from Hyderabad to Kurnool. I want to change the registered office, say, from Kurnool to Khammam within Telangana. Then special resolution is required to be passed. After board approval, general meeting approval, special resolution, then you inform the ROC. Third one, change of registered office from one jurisdiction of ROC to another within the same state. This problem arises only in two places in India, two states in India, Tamil Nadu and Maharashtra. In Tamil Nadu, we have got ROC Chennai, ROC Coimbatore. In Maharashtra, ROC Pune, ROC Mumbai. So some districts come under their control. So within the same state, if you are changing the registered office, then whose approval is required? Not only the special resolution, regional director's approval also will be required. So RT's approval also is required. Now, then you have to file the confirmation with ROC, all those things. Actually, these three is not technically alteration of memorandum. Because memorandum, yesterday I told you, only contains the name of the state where the registered office is situated. So these three changes of registered office technically does not mean alteration of memorandum. There are three procedures. Within the same town, village or city, one place to another is board resolution. From one town, village or city to another within the same state, special resolution. Then from one jurisdiction of ROC to another, these two states within the state, special resolution plus RT approval. From one state to another, it is not only change of registered office, it involves alteration of memorandum also. That can be done only by special resolution and central government approval. Now, unnecessarily, many of us are filing things at the tribunal. They are not going to encourage all the application. Central government, Department of Corporate Affairs, New Delhi, this is a very serious issue because, as you know, control of all the companies is done through state-wise. You have supply control, and even the CIN SIN number also is given state-wise. So from one state to another, special resolution plus central government approval. But then here a lot of procedures. This please ensure before they pass the order, they have to ensure the consent of debenture holders, deposit holders. This is very, very logical here. 90% of the creditors have given the money to you on credit, thinking that your registered office is here. Tomorrow, if you don't pay the money, you will definitely take some action and get your money. So suddenly you shift the registered office from Telangana to Bihar to Lalu Prasad Yadav's house. As simple as that. Where will I go and fight with the company? Therefore, what the government would say, better you pay all the creditors, debenture holders. That is not possible. Obtain their consent. If they're not also giving their consent, then you make sufficient provision in the accounts to pay their money or provide some additional security. The creditors are to be satisfied before the government gives you approval. Then you file with the registrar. Then the registrar, what he will do, he will shift the entire file to another registrar of that state. Then housekeeping work and all you have to do, name boards, letterheads and all that, you do the housekeeping work. Alteration of objects loss. Alteration, very simple. Yesterday also we discussed, just pass special resolution. There's no need for any central government approval, tribunal approval, nothing. Just to pass special resolution and you file the necessary returns with ROC. That's all. You can go ahead. Liability clause cannot be altered. A company limited by shares cannot be made unlimited. All those things cannot be altered. Then I'll come to alteration of capital clause later. How do you alter the articles of association? This is also quite simple. Just pass special resolution. You can alter any provision of the articles. Just pass special resolution and in 15 days you have to file with ROC the returns. And make changes in every copy of the articles. That is all fine. Now look at this issue. There are a lot of case laws on the subject. There are a lot of department clarification. While the procedure to alter the articles is simplified to a very great extent, that you just pass special resolution, alter any provision of the articles, keep in mind these 7-8 points before you touch the articles. 1, as we already said, it is subordinate to memorandum. Don't make any alteration inconsistent with the memorandum. If you make the alteration, I'm not saying the alteration is void. I'm saying memorandum will prevail. Look at the language. Suppose the memorandum writes very clearly, the company cannot exercise borrowing powers. You have made an amendment in the article saying that these are the borrowing powers of MD. It's in conflict. So now the law says, I'm not saying this alteration is void. I'm not using this language. This alteration in the articles will be eclipsed, cover. As of now, it's of no use. Memorandum will prevail. Tomorrow you alter the memorandum and say the company can exercise the borrowing powers, then the eclipse will go away. This is the language. At that time, I don't have to alter the articles again. What he says, if you use a conflict, memorandum will prevail. Then it should not be inconsistent with the Companies Act. So these are all the issues. Now you see, for example, in a public company, 21 days notice has to be given in a public company. Can you say that, if 14 days notice is enough in your articles in a public company? No, blatant violation of Companies Act. But can you say 24 days notice? Yes, if it is an entrenchment clause. That is the point which I'm trying to say. What is in conflict with the memorandum articles is a big subject of discussion. What is in conflict? So not in conflict with the memorandum, not in conflict with the Companies Act. It should not be anything illegal or against public policy. What is illegal, what is against public policy depends on facts of the case. Something like it's a gun manufacturing company and you write one clause in the articles, in order to protect the citizens of the country, it is the discretion of the board to supply one gun free of cost to the chowkidars in the various flats in the country. What? No, all that will not be permitted. Without government license, you cannot sell it. It should be the bona fide interest of the company as a whole, not to benefit a group of shareholders. These are small issues which are trying to miss out. For example, it is written very clearly that the company, before forfeiting the shares, has to give notices, say 21 days notice or 30 days notice. Now, I want to amend it to make 45 days notice. Before making the proposal, I find out 90% are paid the call money. Only 10% are not paid. By increasing the figure from 30 days to 45 days, it is going to benefit whom? Not the majority shareholders, not the company, only the minority shareholders. Then probably this is a big question mark, this kind of amendment. It should be. The company cannot justify a breach of contract. Very interesting point. Suppose the company has got powers to sell some surplus land. They have entered into contract with an outsider. Agreement of sale is over to sell the surplus land. MD has got powers to sell. Now they are making an amendment in the articles, removing the powers of the MD and giving the powers back to the board. So the purpose of the amendment is only to cancel the contract with the outsider. So now the outsider cannot proceed further because MD doesn't have powers at the time of entering into sale deed. So the law says you can't do such alteration to justify breach of contract. Then next sentence he beautifully says, though the right to alter the articles cannot be questioned, they will remain liable for damages. That means, okay, still if you want to go ahead with the amendment, but the party, the third party whose contract is being breached because of the amendment, he will sue you not for compensation, he will sue you for damages. So better you don't make such articles. Then alteration should not constitute a fraud on minority. Simple example, the Companies Act gives rights to minority shareholders. For example, can you say dividends, you make amendment in the articles like this, dividends will be paid only to their shareholders who have minimum 5 shares. Right shares, bonus shares will be given to only those shareholders who have at least 100 shares. These are nothing but fraud on minority shareholders. It should not be inconsistent with the orders of the court. Court order is also a source of law. When court has given an order, you cannot nullify it by amending the articles. This is very important one. It's a company limited by shares. You cannot do any amendment to increase the liability. How the increase in liability? For example, you are holding 100 shares of 10 rupees. Now you can't make it 100 rupee per share. 100 shares of 100 rupees make 10,000 rupees. Originally, you are taken 100 shares of 10 rupees, 1,000 rupees. Now you are making an amendment that the nominal value of 10 rupees will become 100 rupees so that your liability becomes 10,000, 9,000 increase. Such an amendment will not be permitted. Then we'll discuss later on how to convert a private company to public company by just amending the articles. But reverse, converting a public company to private company, you require central government approval. That cannot be done. Then another one, creating a reserve capital. Uncalled capital, you pass special resolution and make a reserve capital stating this capital will not be called except in the event of IDGAP. This to protect the creditors. Once you create a reserve capital, you cannot make another amendment and make it unreserved capital. So keep all these points in mind. These are all not given in the Companies Act, but they are all based on secretarial practices and case laws on the subject. So if these things also happen, then court will take a different view in this matter. We will now quickly run through what is the procedure to convert a private company to public company. Why you convert a private to public? To loot the public, sir. Because business operates in dynamic environment, not in static environment. Expansion, modernization, diversification is the order of the day. For everything, you require more capital investment. So a lot of restrictions are there in private company. You should not have more than 200 members, all that. So now you are decided to open up that we'll go for public issue prospectus and all. For that reason, now you are going to convert a private to public company. And unfortunately, he has not given a procedure in the Companies Act as to how to convert a private company to public company. No procedure is given. Why they have not given procedure? In my opinion, not required also. Why no procedure? Why not required? If you read very carefully, what is a private company? The three restrictive clauses appearing in the articles make a company a private company. Look at the beauty of the definition. Just because the name ends with the word private limited, just because you got 2 members, 2 directors, it will not become private company. They are all characteristic features, that's all. The moment I say it is a private company, I have to look into the 3 restrictive clauses in the articles. That only makes a company a private company. So how do you convert it? Very simple, no procedure. Remove the 3 restrictive clauses by amending the articles. It becomes a public company. That's all, as simple as that. Remove the 3 restrictive clauses by amending the articles. And also in the same, if you want, once you become a public company, you also amend some of the provisions which are inconsistent with that of the public company. Okay, if you don't amend also, then the provisions of Companies Act will take over. That's all, very simple procedure. So what do? First amend the articles to delete the 3 restrictive clauses. Then you have to apply to ROC and get a fresh certificate of incorporation here also. So naturally, what the ROC will insist, because in a public company, minimum 7, so increase the number of members, allotting the shares or registering the transfer otherwise, and number of directors, if there are 2, make it as 3. That minimum paid up capital requirement, all that has gone now. So these 2, you do it, come on. Then you file the articles and the special resolution and these details with the ROC. ROC will give a fresh certificate consequent to conversion. Though the company becomes a public company from the date of passing the special resolution, the word private can be removed from the name only when ROC gives you the fresh certificate of incorporation consequent to conversion. All that now he is giving online, all that. Now the alteration has to be effected in every article, otherwise punishment. What is the procedure to convert a public company to private company? Reverse procedure. But 2 issues I would like to tell. Don't jump into the procedure. Before you look into the procedure, the most important point is you have to bring down the number of members to 200. that you think of. Already, let us say you are a listed company. There are already 12,000, 13,000 members. By just looking into a procedure, it becomes impossible. So how do you reduce the number of members? Forget buyback of shares. Hell, a lot of procedures are there. Buyback we'll discuss much later. So how do you do? It is only the major shareholders have to go on purchasing their shares in the open market and try to reduce the number of members around 200 or below 200. Then you think of procedure. So it is impossible for companies which have 500 members or 1,000 members or 5,000 or 10,000 members to convert into private company. Not possible. So the system or the idea to convert into public company is a long drawn process. I still remember when Rasi Cements Limited was taken over by India Cements. Rasi Cements was a listed company, and then they wanted to convert into a private company. It took a lot of time. They had to purchase their shares in the open market and all. So that is the first point you must keep in mind. Procedure and all we'll see later. Come on, what is the procedure? Insert the 3 restricted clause in the articles. How do you insert? By passing special resolution, and central government approval is required. While converting a private to public, no central government approval. Public to private, central government approval is required, because government would like to go through how much of shareholders are there, how you have paid the amount to them, what about the debentures, what about the other people whose interests are all affected, they would like to go through. So insert it, and also make amendment to the articles, inserting the other clauses we want to take advantage. I mean, the other provisions in the articles by special resolution. Then, as I told you before, taking the initiative, restrict the number of members to 200. Then once this is over, again, you file it to the ROC. ROC will issue a fresh certificate, inserting the name private. And please understand, both in conversion of private to public or public to private, it is not a new in company, just like change of name. So the same legal entity will continue. That's all, same books of accounts, same members, same directors, same litigations, everything will continue. Here, one more extra point is, if it is a listed company, then you have to inform the stock exchange. This is practically not possible, because if you, how do you have to purchase the entire shares? So anyway, if it is a listed company, you have to inform the stock exchange, price sensitive information, otherwise you can be booked for insider trading. And also before, you have to file a delisting application, because once you become private company, henceforth you will not be listed. But then you make necessary changes. Now there is one issue here. What there was earlier, what about a situation where you are basically a private company, but you violated the provisions of the Companies Act regarding restricted clauses? If you violate the provisions of restricted clauses, it becomes a public company. Please understand. It's a very peculiar situation. I want number of members more than 200. Or I have issued shares to the public. I have violated any one or more of the restricted clauses. I become a public company. The law says very clearly that you are to comply with the provisions of the Act as if you are a public company, retaining the 3 restricted clauses. Look at the fun. Earlier, there was 43A deemed companies. Those concept is not there in the new Companies Act. So in such a situation, if it arises, better you try to rectify. That provision for rectification also is not there now. So the only thing is you go for voluntary conversion to public company. So there is no provision in the Companies Act. How do I deal with a situation where I violated the provisions of the restricted clause? Then still I am retaining the name private, but as per law, I have to comply with the provisions of Companies Act. So there is no answer in the Companies Act, in the present Companies Act, in that situation. Now I'll spend substantial time in incorporation of company. Incorporation of company. Now, yesterday, the Assistant Registrar also told that the SPICE form, SPICE Plus form, is a very comprehensive form which includes everything. So keep in mind before you incorporate that 2 subscribers are enough, and then the name should end with the words private limited. These are 2 specific factors. and the 3 restrictive clauses must be there. These are basic requirements. And I told you there is no necessity for any minimum capital and all that. Now, they need not be filed many forms. One comprehensive form contains everything, the SPICE form, modified one. Broad headings I'm telling you. First, it talks of type of company, class of companies, all those details. Then the capital structure, address for correspondence, proposed name. Now here, yesterday I told you, you have 2 options. The part A of the SPICE form, you apply for the name, get the name. After that, you fill up the details, and part B of the SPICE, you fill up and incorporate the company. Second option is, at a time you get the name availability as well as incorporate it. But there are a lot of practical difficulties. Getting the name approval is not that easy. When you file everything and you don't get the name approval, the same time it takes. So my suggestion at a personal level will be, even though they are trying to streamline, something like run form part A is there. Better you apply for the name, get the approval, and then you fill up the part B and then go for incorporation. So write the proposed name, particulars of subscribers, particulars of first directors, then information for PAN, TAN, PF, VS registration, IEC code number information, particulars of investment, and you have to enclose the memorandum articles also. Memorandum pattern, you have to fill up the main objects, incidental, all those articles we discussed enough. If you adopt table F is given there, you have to make the changes or keep as it is. And then the declaration also has to be signed, and the declaration must be given by a professional. All those things have been incorporated in the form itself. You have to now fill up online. It takes a lot of time, lot of problem for you. And then you have to pay the registration fees, filing fees, and all that. So in that form, this I cannot explain. You have to practically sit in front of a computer and take a SPICE form and do it. But some issues I would like to discuss. Now, all the subscribers to memorandum must have digital signatures. Now everything has to be signed online only, no physical signature, no attachments. Earlier what we used to do, memorandum articles, we used to attach it. Now it's not permitted. They should have digital signatures you obtain. So for that you should have PAN and other address proof and all that. Digital signatures you must have, all the subscribers. Second, every proposed director should have already obtained a DIN, Director's Identification Number. We are discussed, there's a provision in the Companies Act which says, if you don't have a DIN, Director's Identification Number, you cannot become the director of the company. Now, the facility is either before becoming the director itself, you have a DIN number with you, excellent, or along with the incorporation documents itself, you can file for DIN. That provision is available with you. You may not have a DIN. So at the time of incorporation itself, the ROC will give you DIN number. That facility is now available. For that, you have to enclose the necessary enclosures, including PAN number, Aadhaar card, photos, all those details, whatever it is. Right. Now, yesterday, the Assistant Registrar of Companies was talking, along with the certificate of incorporation, 10 approvals are also given. Let me discuss on that in the new SPICE form. The first one, the certificate of incorporation. The second one, name availability letter also. This already discussed. If you want, you better take the name availability much earlier. Or along with the documents of incorporation itself, they'll give you name availability. So 2 things are over, certificate of incorporation, name availability, then rest 8, totally 10. Then DIN already we discussed. Along with the application, you already got it, excellent. Or along with the SPICE form, you will be given DIN number also. Now, surprisingly, apart from the SIN number, corporate identity number, which will be given along with the certificate of incorporation, PAN number of the company also they are giving. TAN number, tax deducted source, the TAN number, PAN number of the company. Now, ESI registration, PF's registration also will be given along with the incorporation. Wonderful. Then GST registration number also can be given, but he says it is optional. But I understand from many consultants, sir, with this practically still The software is not that well developed. So still we have to apply and give many documents and all. Anyway, as of now, the theory is GST also you can apply, you will get it. Probably the number you will get, you have to file other documents. Bank account also. They have identified some 6-7 banks where automatically the account will be opened. Here also I find a lot of problems the professionals are facing, because in bank asks for additional information. So who want to operate the account, what type of account and all. Maybe immediately you get a bank account number, so the delay is reduced and you file all the documents and immediately you get it. Then I've seen one column, import-export code number also. But there's a column, do you want a yes or no? They have said. If it is yes, you put a tick. But there also, I have confirmed from many sources, you will not automatically get the import-export code number. You have to apply to them with details. Maybe over a period of time that they will have proper coordination with the bank's import-export code number and GST. And over a period of time, it may be possible this wonderful development along with the incorporation now, all the 10 economic approvals also. I repeat, name availability you can get directly, certificate of incorporation along with the SIN number, then DIN of the directors also you can apply and get it simultaneously, PAN number, TAN number, ESA approval, PF approval, GST approval, bank account opening, and also IEC code number. All this is what the assistant registrar was talking yesterday. Incorporation. And I told you from the date of incorporation, they will also allot the corporate identity number. Yesterday we discussed that corporate identity number must be put in every letterhead, name boards, billboards, all that, so that tomorrow, if it is online, I want to know something about the company. If I got the SIN number, I'll be able to go through the files of the company. It will be included. And then from that date, it becomes a legal entity. Now, effects of registration, this you read. So from the moment the company is incorporated, it becomes a body corporate, a separate legal entity. So it will have perpetual succession. They can hold disposed property. It's a separate person by itself, a legal entity. It can be sued in the name. All that is fine. Then they have all this. Now, one new provision they have added in the 2013 Act. After incorporation of the company, if it is proved that the company got incorporated by false or incorrect information or suppressing the material facts. So incorporation is not the end of the story. Or you have filed all wrong documents, this, that, and all, or by any kind of fraudulent action, what they have done, the promoters and the first directors named and the person making the declaration shall be liable for fraud, 447. When I go to 447, we'll discuss imprisonment from 3 years to 10 years plus fine. So be very careful. You consultant, you are also responsible because you make a declaration. The proposed director or consultant that I have complied with all the provisions of the Act, including matters incidental and consequent to incorporation. You make a declaration. You make a declaration, I have complied, all the statement is true. But later on after incorporation also, if they find, then all these people will be liable for action. Then what about the company? Then they will pass such orders for regulation of management, changes in the memorandum articles, or the liability will be made unlimited. Look at the extraordinary power of the government if you get a company incorporated by the false information. Or they can remove the name from the register or pass an order for winding up or such other order as they deem fit. This is the extra provision they have now. However, they should give opportunity to be heard because the matter will be decided by the tribunal only, all that. Now, conclusive evidence of certificate of incorporation. I would like to spend some time here. What do you understand by conclusive evidence? The judge has not seen the crime when it took place. Judge has not visited the scene of crime. The judge sits in the courtroom under a AC or fan and gives the judgment. On what basis? Evidences. On the basis of Indian Evidence Act. There are various types of evidence: oral evidence, written evidence, express evidence, many types, implied evidence, then provable evidence, then evidence which need not be proved, like that. Out of that prima facie evidence, then what is conclusive evidence? The conclusive evidence means the facts speak for itself. In other words, once the ROC has put the signature in the certificate of incorporation, of course, now digital signature, all that, it is like birth of a baby. The company has come into existence, it has born, it has come into the world as a separate legal entity. If you tear off the certificate of incorporation, throw it, it has no legal effect. It's like birth. If you don't want a child, you should have planned long back. Now you cannot kill the child. That's the best comparison. In other words, any mistake in the incorporation of the company cannot be pointed out to the registrar of companies, because once the conclusive evidence means whether the rules and regulations are complied with or not, it is deemed to have been complied with, and the company has come into existence as a legal entity. Just now we saw, even though these mistakes were there and ROC has given a certificate of incorporation, he can only punish the promoters and other people, directors and all, but still the company was in existence for 1 day, 5 days, 10 days, and you have to kill the company only through strike off of name or through winding up. So legal entity cannot be destroyed. In other words, there were a lot of mistakes in starting a company. For example, he has not paid, it cannot happen, but if it happens, main objects were missing, then he has not paid the authorized capital, serious mistakes. And the company was incorporated, conclusive evidence. So defects cannot be raised. That is the most important point. All the requirements of the Act, including rules made under, including matters precedent and incidental, is deemed to be complied with. Whether you are already complied with or not, deemed to be complied with, and the company has come into a legal entity, it is born the moment it is incorporated. ROC has signed the certificate of incorporation online today at 12:46. At 12:46, company has come into existence. In other words, where there is incorrect information and all that, you will be liable to action only under 447. But though the certificate of incorporation is a conclusive evidence, it is only conclusive of what? The provisions of the Act relating to incorporation is deemed to be complied with, and the matters incidental precedent, and the company has come into existence as a legal entity. But illegal objects will not become legal. Once illegal, always illegal. Suppose, say, for the fun of it, one fellow wrote in the main objects clause to kill all the 224 MLAs of Bihar, starting from so-and-so, so-and-so, and the ROC incorporated without looking at it. Then after incorporation, the MD cannot say, come on, take all your equipments and go to Bihar and do your job and complete the job within 1 month. If a DGP of Bihar talks, you show the certificate of incorporation, nothing doing. Once illegal, it continues to be illegal. So please understand, at few places in the Companies Act, he has used the word that conclusive evidence. What I'm trying to say, even without finding any document or lot of defects in the document, once it is incorporated, the defects cannot be raised in the court of law to destroy the incorporation. You may take action, you may put fines, you may wind up the company, you may strike off name, but the company has come into existence for few minutes, few seconds, few days, or even few weeks and months. This is the importance of certificate of incorporation. Now, commencement of business. Go back. Earlier in the old Companies Act, a private company can commence business the moment it is incorporated. But a public company was required to take another certificate known as Certificate of Commencement of Business. And all the contracts in a public company entered after incorporation before getting the certificate of commencement of business were called provisional contracts. Then in the new Companies Act, what happened? They totally abolished this concept of certificate of commencement of business even for public companies. They totally abolished it. Then again, through an amendment, they have brought back this certificate of, and they got back this commencement of business. But only change is the ROC is not going to give a certificate. After incorporation of the company, I repeat, this applies to both public as well as private companies now. After incorporating the company, you are to file a declaration from 2019 onwards. After incorporating a company, I repeat, both public and private companies, you are to file a declaration with ROC that within 180 days of incorporation, say roughly within 6 months, and it should be signed by the, verified by the company secretary or chartered accountant, cost accountant, that every subscriber has paid the shares taken by him. That's the main declaration. So you have agreed in that the time of incorporation, I'll take 5,000 shares, 10,000 shares and all. So whether you have already taken it, the already taken means what? That you have paid the application money and all that to the company. That declaration has to be filed. And it should be verified and filed with the registrar. And once you file, and also if the company was pursuing objects which required RBI SEBI approval, their approval also was to be taken. And after filing these documents only, you can commence business. ROC, as I told you, will not give any special certificate, but after starting only, after filing all these documents only, you can start the business. Default to see 50,000 penalty, every optional default 1,000 every day, not exceeding 1 lakh. Now, if you are not filed this declaration and document, ROC can initiate action for removal of name, strike off of name under the chapter. They can go for strike off of name under the chapter. So now my point of discussion is, and only after you get the certificate, you can exercise borrowing powers and enter into contract. Now a question arises, is there provisional contracts? I have checked up various books, I don't find this. So I also come to a conclusion, there is no such concept called provisional contracts. There's only one declaration which you are to file. In other words, what about the contracts entered by the company after incorporation and before filing these documents to obtain the commencement of business? They will not be classified as provisional contracts. So in other words, who will be responsible? The company will take responsibility. So my stand will be, it should not be treated like certificate of commencement of business. So my stand is, this is one of the documents which has to be filed. So there is no such concept called provisional contracts. There is no such concept called provisional contracts. So preliminary contracts and regular contracts. So my point is, even if you don't file this certificate, the consequences are terrible, but still whatever contracts were entered by the directors, which are within the framework of the Companies Act memorandum articles, the company has to take the responsibility. There's no such concept called provisional contracts. Next, I would like to start with this private placement guidelines. Since I've got time of 15 minutes plus, I would like to start with the private placement guidelines. First, gone are the days that in a private company, whenever you want, you will take application money and allot the shares. That mindset has to be changed. Previously, what we used to do, one member gives some application money, we used to allot the shares. Whenever then you file the necessary returns with ROC. Whenever you want, you take application money, you allot the shares. Now everything has been streamlined. Everything has been structurized. Even in private companies, what are the guidelines? First, private company issues can be classified in 3 broad categories. Rights issue, bonus issue, private placement. So whenever you want to allot the shares, it comes under the regulation called private placement. If it is a public company and listed, then one more thing we can add, public issue. In public issue, that is regulated by SEBI guidelines. So a private, since our discussion is only with reference to private company, 3 types of issues we have got. One is private placement, the second rights issue, bonus issue. Rights and bonus we'll discuss later. First, private placement. What are the guidelines? Before that, what is allotment of shares? Technically, they have not defined what is allotment. So you have to go to the Contract Act. Allotment is offer plus acceptance of is arises a contract. Like that, allotment is nothing but acceptance. On allotment, the contract comes into existence. In one of the Supreme Court judgment, he beautifully said, allotment is appropriation of previously unappropriated capital of the company by the board of directors into certain number of shares in favor of certain person who has made the application for shares. Beautiful. 2 things. Allotment is appropriation of previously unappropriated capital. Shares are lying on my table. They are unappropriated capital. So in allotment, what you do? 2 things you do. You identify the name of the person and you also identify the number of shares, which is done by the board of directors, is allotment. For example, you pass a resolution like this. Resolve that 5,000 shares under distinctive number so-and-so B and D is hereby allotted to such person as decided by the managing director. It is not allotment because you are not specified the name of the person. Another example. Resolve that Mr. A. Jayaraman B and D is hereby allotted with such number of shares as decided by the MD. It is also not allotment. So 2 things must happen in allotment. You have to decide the name of the person and number of shares. So it is appropriation of unappropriated capital. These 2, if you decide, it is allotment, and this will be done by the board of directors. So on allotment only shares come into existence. It becomes the paid up capital. That's why reissue of forfeited shares is not allotment. Because in reissue of forfeited shares, already you have decided the number of shares. Only thing, you are changing the name of the person from one person to another. So only on allotment you have to file the returns with ROC. Reissue of forfeited shares, you don't have to file any returns with ROC. Having understood what is this allotment, what are the private placement guidelines which apply for private companies? There is a separate section 42, and these are all newly amended sections introduced in 2019 or 18. In other words, I'll give some introduction. No longer it is possible that you take some money from unknown persons and you just allot the shares directly to him. All that is not possible. You should have a plan of action, just like a public issue, just like prospectus. Even it's a private company. Now I've got a project, and this project entails 2 crores. Very systematic activity is allotment now. So from where do I get the money? First, you identify who are your relatives, friends, associates, because you cannot subscribe for the public issue. From where you will get the shares within the 200 people. Then you have to prepare one application form you have to private placement offer application form. Gone are the days, even though it's a private placement, that these people apply for the shares or relying on the background of the promoters and the company. Gone are the days where they are going to blindly put the investment. So let's start. Private placement is offer to a select group of persons. First you identify, do the homework. From these 50 people, I have to take the money. Then directly you cannot issue. You have to issue one letter. Previously, it was like statement till your prospectus like that. Now all that has gone. The application form itself must be supported by private placement offer letter. And it is called private placement offer and application form. It contains some details which are prescribed in the Companies Act. This is called private placement. What is a private placement? It is offer of securities, not only shares, debentures, what are come under the definition of security, to a select group of persons, not one person or two persons, maybe one or two persons, but not whenever you want. Select group of persons, you identified who are there, and through private placement come application letter, which satisfy the following conditions. What are the rules? Now, the private placement to select group of persons. What is the maximum number of persons? 200. That is obvious. Why the 200? Because in a private company, the members are restricted to 200. However, this does not include qualified institutional buyers and employees. Now, in the definition of company itself, private company, employees who are members are excluded in the calculation of 200. But institutional QIBs will be included. So anyway, QIBs altogether, it should the 200 calculation you have to keep in mind in a financial year. Next, the company making private placement offer letter whose name are recorded. See, first you talk to the people, get the letters from them. In the board meeting, you decide 1, 2, 3, 4, 5, 6, 7, 8, this 30, 40 people only I'm going to allot. Take their consent letters. And then you signal the application form to them. Then the private placement will not have right to renounce. So if the board has decided to allot the shares only to Jayaraman, they should allot only to Jayaraman. Jayaraman cannot renounce and give it to some other person, no renunciation. Then every identified person should pay the money through check, draft or banking channel, not by cash. So auditors must note that share application money given in private company should come through private placement, not by cash. It has to come through checks only. You have to report this in the audit report if it is a violation. Check, demand draft or banking channel, not by cash. Before this amendment in the old guideline, the auditor or the company also has to ensure that the money comes only from that person, from his bank account. Thank God they have removed that. At least a little bit freedom is there. So if I have to apply shares in my son's name, probably I can give the check. That is the small freedom available. So next guideline says, the company should not use the money raised unless allotment is made and return filed. Hey, similar like public issue. Whatever money you receive from the 30 people, 40 people, the application money, say about 2 crores, keep it in a separate bank account. You cannot withdraw the money. So what you have to do, allot it and file the return with ROC. Because tomorrow in some situation where you are not complied with the guideline, you have to refund it. You are not complied with the guideline, a situation will arise where you have to refund it. Then where will you get the money? So therefore, similar to public issue, keep in a separate bank account. We'll discuss that. Don't use that money for the business purposes. So first you allot the shares, let the money come from all. Allot the shares, not only allotting, file the return with ROC. And all this the auditors to verify and check up private placement guidelines. And no allotment shall be made, no fresh offer unless it is over. So when one offer is pending, you cannot start another offer. Of course, you can give 2, 3 offers within a year also, but one offer is pending, you cannot go for another offer. Look at the time limit now. Within 60 days from the date of receipt of application money, you have to allot the shares. Similar to public issue now. You can't keep the application money for 1 year, 2 years, and then allot. All that is gone. If you don't allot within 15 days, similar to public issue guideline, within 15 days, we repay the application money, failing which you have to pay 12% rate of interest. 60 days is over, another grace time of 15 days is available to you. If you pay, excellent, refund it or do whatever it is. If you refund it, fine. If you don't refund within the grace period of 15 days, 12% interest you have to pay. And all the money received should be kept in a separate bank account, and that can be used only for repayment or adjustment after allotment. In the meantime, you cannot use for any other purpose. As I told you, it's not that you'll receive the money and before allotting, you'll use for your business purposes. The company is prohibited from publishing any advertisements in the media or any. You can't appoint brokers, sub-brokers. You cannot pay underwriting commission. You cannot pay anything. It's a private placement guideline. You cannot give any advertisements because you have identified the person. How you talk to him, you talk to him. You are not going to allow all those expenditure. And let them also involve themselves in informed decision-making process. In the private placement offer letter, let them read. It should go along with the application form. And when the company makes the allotment, you have to file with ROC, return within 15 days, not 30 days. File the return of allotment with ROC. Look at it. If you make a default, the company and promoters are liable to default 1,000 rupees every day up to 25 lakhs. The recent amendment also, they have not changed the penalty. Now comes the best joke. Subject to that subsection, a company makes an offer in contravention with this section. This is earlier one default in procedure. Here you contravene the sections. The company, promoter, everywhere he is using the word promoter, directors, penalty of the amount raised through private placement. Violating the guideline, you are raised 5 crores. 5 crores or 2 crores, whichever is lower. You are raised about 10 lakhs. 10 lakhs is the penalty. And the company should refund all the money with interest within 30 days of the order imposing the penalty. This is the private placement guidelines which you have to seriously follow. And if the company offers more than 200 persons, then the provisions of public issue will arise. Look at it. If by chance it is going to more than 200, then it is equivalent to public issue and your SEBI Act and Securities Contract Regulation Act will apply. Apart from that, in the rules they are provided, first, the proposed offer should be approved by special resolution. There's nothing great in that. When I go to rights issue, we'll see any further allotment of shares will be treated as rights issue. We have to give to existing shareholders. If you want to avoid the right issue, even in private companies, we were earlier, these restrictions were only for public company. Now, even private companies, if you want to avoid the right issue, anyhow, you have to pass special resolution. So that special resolution passed, this is given in the rules. When you pass this special resolution, let the shareholders involve themselves in informed decision-making process, not blindly passing. Further allotments you are making. It's a private placement. What are the particulars of offer? When did the board approve it? What kind of security? Price. This is the big issue. You are avoiding the right issue. You are giving to some other person. Existing shareholders, you gave at 10 rupees. Again, you are giving at 10 rupees only. So what is the price? Please give it at a higher price so that existing shareholders are benefited. Otherwise, they will not allow you to pass the special resolution. And that price should be approved by the valuer. So any private placement guideline today, after 6 months or 1 year or whatever time it is, if you want to apply, valuer certificate is required. Valuation has to be done. And material terms, you write all proposed object, object of the offer, contribution by the promoters, for principle of terms, what are the security, everything. Let the directors, let the shareholders approve it, involving themselves in informed decision-making process. And then this, you have to file with the registrar. And then this private placement letter also should be in PAS 4, serially numbered and addressed to the person and sent to him in writing or electronic mode within 30 days of the name. So first you have to talk to that person and send this offer letter. Then no other person will be allowed, no renunciation, nothing. To whom you are given, only that man has to apply for the shares. That's it. So thank you very much. Thank you for your patient listening. As I told you, now my telephone number is available to you. I repeat again, 94-901-90956. So you can give a personal WhatsApp message to him. To me, I will answer it. That will be more helpful. In case I feel some of the issues are very predominant, I will myself put that issue in the WhatsApp group. The reason is I can spend more time because within the limited time, I have to cover many areas which is helpful to the members. So I appreciate your doubts. Clear, get it clarified. You send it to me, my personal WhatsApp number or email, ljayaraman@rediffmail.com, LJAYARAMAN, all small letters, ljayaraman@rediffmail.com. Thank you very much, sir. Over to the chairman.
Thank you, sir. Thank you very much for the non-stop, that is GT and Tamil Nadu Express, something like that, which starts and never stops. So really, really super. It is a Rajdhani Express, in fact. So thank you, sir. Thank you very much for a wonderful session on the Articles of Association and connected things. Tomorrow, exactly by 6 o'clock, we'll start. Okay, sir. Thank you, one and all, for the patient listening. And as sir is telling that, you please place your questions. All the Q&A, what are the questions that are available? You please kindly put the same in the WhatsApp group so that sir will reply the same. Thank you. Thank you, one and all.